For debts of at least $2,000 owed by a corporation, a creditor can serve a company with a statutory demand. It's a formal demand for payment under the Corporations Act. If it's not satisfied by a debtor within 21 days period, it creates a presumption of insolvency against the company, which can have potentially serious implications on the debtor, including an opportunity for creditors to apply to have the company wound up. Accordingly, a good corporate entity is unlikely to simply ignore a stat demand, so it creates a level of urgency in resolving an outstanding debt. However, stat demands should only be used in circumstances where you anticipate the debtor will not be in a position to dispute the indebtedness to you. A debtor that disputes that money is owing or has an offsetting claim against you can apply to the court to have it withdrawn and set aside within 21 days. They only need to satisfy the court that they have a genuine argument, even if their argument is perhaps unlikely to succeed at trial. It's a low threshold and relatively easy one for the debtor to reach. If they can satisfy the court of that low threshold, you may end up wearing a costs order against you. To that end, you should generally seek advice from your lawyers as to whether a stat demand is appropriate in all of the circumstances, and get them to draft it while you're at it. If a stat demand is not properly drafted, it will be considered defective and it will be of little help to you.